Module 3. Unprotected Speech. The First Amendment right to free speech is not absolute. As Supreme Court Justice Oliver Wendell Holmes, a strong advocate for free speech, famously wrote, "The most stringent protection of free speech would not protect a man in falsely shouting fire in a crowded theater causing a panic." Courts through the years have carved out exceptions to the right to say what you want, where you want, when you want, and this module and the next one will explore some of the most important of these exceptions. With regards to each category, courts have had to decide how to balance the constitutional right of a party to free expression and the need of society to restrict such speech for various reasons. Commercial speech. Commercial speech means speech on behalf of a business with the intent to make a profit. It's different from political speech, and so can be restricted in ways that political speech cannot. It includes advertising and speech on television, radio, print, internet, public relations statements, and other sales documents. Commercial speech can be regulated to a point. It's protected by the First Amendment unless there's a convincing reason to restrict it. But regulations of commercial speech don't get the same kind of strict scrutiny protection as does political speech. It gets diminished protection. The analysis of commercial speech is driven by consumer protection. The need of the public to be informed about products on the market is the strong government interest that justifies much restriction on commercial speech. The courts did not recognize commercial speech as a category of free speech at all until 1942, when the Supreme Court held that commercial speech was not protected speech under the First Amendment, and that the government had a right to regulate any commercial speech. In 1976, however, the Supreme Court held that there are some circumstances in which the state could not regulate commercial speech. In that case, the court struck down a state law prohibiting the publication of prescription drug prices. The court said that states could not suppress truthful information about lawful business activity without justification. 4 years later, the court decided another important case on this issue, Central Hudson Gas and Electric Corporation versus the Public Service Commission. Central Hudson laid out a 4-part test to determine when restrictions or regulations on commercial free speech violate the First Amendment. 1. For speech to be protected, it must concern lawful activity and not be misleading. False advertising is unprotected, and is, in fact, the subject of civil and criminal prohibitions. 2. The asserted governmental interest must be substantial. 3. The regulation must directly advance the governmental interest. And 4. The regulation may only be as extensive as necessary to serve the interest. Furthermore, there must be a reasonable fit between the government's ends and the means for achieving those ends. Over the years, various cases under the Central Hudson test have been decided over the issue of substantial government interest. For instance, the court held that Puerto Rico had a substantial public interest in restricting advertising of casinos to its population. Moreover, laws and regulations can mandate certain language in advertising. Think about the disclaimers that accompany so many prescription drug ads, and mandatory warnings that have been on cigarette packages for decades. The prohibition against government-mandated speech discussed in Module 2 is not generally applicable to commercial speech. Incitement. Incitement is another example of unprotected speech. A similar rule, called the fighting words doctrine, also allows the government to outlaw speech likely to provoke a violent response. Incitement, often called incitement to riot in criminal statutes, means encouraging someone to break the law, particularly inciting a group of people to riot or otherwise engage in behavior that is violent or illegal, or both, like overturning cars or breaking store windows, burning crosses, and attacking or intimidating people. The balancing act here is for the courts to try to protect free speech while also trying to prevent riots and group attacks on people. Case law is replete with difficult decisions on how far speech can go before it is considered incitement, and how far the government can go to restrict this kind of speech. Until 1969, any speech that encouraged a group of people to engage in violence could be made illegal if there was a clear and present danger of violence. The clear and present danger test, which dated back to the famous 1919 Supreme Court opinion penned by Justice Oliver Wendell Holmes in Schenck v. United States, was difficult to apply, as clear and present danger is often in the eye of the beholder. That opinion, incidentally, also spawned the fire in a crowded theater metaphor. The Supreme Court replaced the clear and present danger test in the 1969 case Brandenburg v. Ohio. The Brandenburg court overturned a conviction against a Ku Klux Klan leader for inciting a riot when he told a rally on an Ohio farm to take revengeance against various groups of minorities and federal agencies. The court stated that to lose First Amendment protection as incitement, speech must be directed to inciting imminent lawless action and likely to produce such action. Likelihood and imminence are higher thresholds than just clear and present danger. It requires an immediate threat. Merely spewing hate is constitutionally protected. The court refined the test further in another KKK case in 2003, where it defined true threats as those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. The court noted that the speaker need not actually intend to carry out the threat. This case concerned a cross burning as a specific threat. The court overturned Virginia's law against cross-burning, holding that the law needed to include a provision to require that the crosses were specifically burned to intimidate for the law to pass constitutional muster. Crimes involving talking and agreeing. Just talking is not a crime. Talking about a crime is not a crime. But planning a crime might leave the realm of free speech and become a criminal act. At that point, talking about a crime becomes a crime called conspiracy. Conspiracy may be charged separately from the underlying criminal act and does not require the underlying criminal act to take place. The elements of the crime of conspiracy are an agreement to carry out a crime, combined with the specific intent to further the criminal objective. To ensure that the talk is serious before finding criminal liability, most jurisdictions require at least one conspirator to have taken a physical act towards committing the crime, known as the overt act requirement. This could include casing the joint or purchasing guns or other criminal tools. The crime of conspiracy can clash with freedom of speech rights, however, when it is used to arrest people for political speech, as happened to several members of the American Communist Party in 1948. In that case, the Supreme Court upheld the arrest of 11 people attempting to create that party based on the clear and present danger test. In retrospect, it may seem unlikely that a few guys talking, sitting around discussing politics, was a danger to the country, but that was what the Red Scare was all about. Conspiracy laws are still used today to try to stop potential terrorist attacks by parties as diverse as ISIS and the KKK, and to attack organized crime. Blackmail and extortion. Extortion and blackmail are crimes that typically are accomplished by the spoken or written word. Blackmail is the threat to bring a criminal case in order to settle a private civil matter. It's a form of theft. An example would be a person threatening to go to the police about a crime unless the person who committed the crime gives the blackmailer money. The truth of the accusation is not relevant to this crime. Extortion is the threat to release private information to the public or threats to the person's well-being unless the extorter is given some consideration, like money or sexual favors. Federal extortion statutes also criminalize threats against the president or a governmental authority. Some threats by government employees, such as a police officer threatening arrest for no reason, mailing or electronically transmitting threats, and several more categories. They are all felonies. State laws vary widely in their applications of these concepts. For instance, some states only charge public authorities with extortion, while charging private citizens with blackmail. Some states call both crimes extortion. Obscenity. Obscenity is a category of speech inherently unprotected by the First Amendment. It can be defined as an act, utterance, or item tending to corrupt the public morals by its indecency or lewdness. Still, not every communication that's lewd, indecent, or even pornographic qualifies as obscene. To be considered obscene and thus unworthy of protection, communication must meet certain legal criteria. Obscenity can be divided into three categories: obscene speech, pornography, and child pornography. Obscene speech. Ever since Clark Gable turned to Vivien Leigh in Gone with the Wind and said, "Frankly, my dear, I don't give a damn," in 1939, American society in general and courts in particular have been vexed by the issue of what's allowable in print, music, or film that people may find offensive. In these days of anything goes on cable TV and satellite radio, it's easy to forget that there was a time in the not-so-distant past when broadcast language was strictly controlled by various government censorship laws. While commercial broadcast television is still somewhat restricted in what can be said or shown, court decisions and popular culture have steadily diminished these limits. Courts struggled in the 1960s and 1970s to define obscenity in any meaningful way, so as to determine whether an obscenity law was being broken. Lenny Bruce went to jail in 1964 for profanity, which was considered verbal obscenity. Though hard to imagine today, Lenny Bruce actually went to jail for swearing. Then George Carlin went to court in the mid-1970s over his 7 words that you can't say on television routine, which was inspired by Bruce, as did a radio station that aired the routine. Carlin won his case, as the Supreme Court ruled that curse words may be indecent but not obscene. These days, prosecution for swearing in public is rare, if not extinct. Obscene words rarely, if ever, are prosecuted anymore. Modern obscenity prosecutions now concentrate on visual pornography, and in particular on child pornography. Adult pornography. Pornography is a communication or imagery that's intended to sexually arouse a person who hears, reads, or views the material. Pornography cases are analyzed under the 1973 case, Miller v. California, the case most famous for Justice Potter Stewart's writing that he could not define pornography, but that I know it when I see it. Miller set forth a 3-part test for determining what constitutes pornography that is unprotected by the First Amendment and thus may be barred by law. 1. The material must appeal to prurient interest. 2. The material must depict sex acts or behavior in a way that is patently offensive in the community. Here, location matters. What is offensive in Provo, Utah may not be offensive in Las Vegas, Nevada. And 3. The material is not considered obscene if, taken as a whole, it has any serious literary, artistic, political, or scientific value. The 3-pronged Miller test has been interpreted by many courts over many years, and is still the standard used by every court in attempting to judge what is pornography. 2 Supreme Court cases have further refined this test. In Smith v. United States, the court held that a legislature's interpretation of how to define community standards does not supersede an individual juror's interpretation of what a community standard is. Then, in Pope v. Illinois, the Supreme Court ruled that in applying the 3rd prong of the Miller test to a prosecution for the sale of allegedly obscene materials, the proper standard of review is whether a reasonable person would consider that the work, taken as a whole, lacks any serious literary, artistic, political, or scientific value. With the modern proliferation of pornography on the Internet, application of the community standards rule has become more and more difficult. Child pornography. Child pornography, on the other hand, is always considered obscene and unprotected by the First Amendment. Sexual images of children under the age of 18 are considered to be contraband under federal and state law and are not protected by First Amendment rights. Federal law makes it unlawful to produce, view, or transport these images in interstate or foreign commerce. It is also unlawful to distribute these images to children on the Internet. The penalties for violating those statutes are severe, including lengthy prison sentences and registration as a sex offender. In addition, all states have child pornography laws on the books, which vary extensively. Other categories of unprotected speech. Perjury and false statements. While it's not illegal to lie, there are specific lies that are punishable under the law. One punishable lie in particular is dedicated to preserving the sanctity of the legal process, that is, lying under oath to a court or a governmental entity like the FBI or Congress. Lying under oath a court proceeding, such as a trial, deposition, or affidavit, is the crime of perjury under federal and state laws. States have various punishments for perjury. Lying under oath in federal court is punishable by up to 5 years in prison. Lying to the FBI or other federal entities is called making false statements under federal law, and violations are also punishable by up to 5 years in prison. Copyright laws. People who write their words own them and can publish them. Copyright law also protects creators by allowing them to stop others from publishing their works. This is so fundamental to U.S. law that it's in the United States Constitution. There are federal and state copyright laws. The first federal copyright law was passed in 1976. Until that time, content generators were protected only by common law and state copyright laws. Copyright law protects books, digital property, art, music, and other original works from unauthorized use. Publishing or otherwise using someone else's content without permission is copyright infringement, subject to some exceptions detailed in federal copyright laws. The Copyright Clause in the Constitution was written around the same time as the First Amendment, and courts have generally pointed to that fact in saying that the two clauses should be read together, with copyright law written specifically as a restriction on free speech. Note that only materials put into a tangible medium are protected by copyright law. Ideas cannot be copyrighted. That makes these written or recorded materials more like property than are ideas which are more analogous to speech. This analysis makes copyright restrictions seem like less of an infringement on freedom of speech. Moreover, the fair use doctrine provides the most important exception to copyright law. It allows use of copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. That allows, for example, use of these materials for parodies, satires, and news reports, thus allowing most expression normally considered most important under the First Amendment. Copyrighted works can be registered with the United States Copyright Office and can display a copyright mark. It is not necessary to register a mark in order to be protected under copyright laws, but registration gives the content owner evidence of having first created the work. Speech at work. The First Amendment protects against speech restrictions by governmental bodies. It does not apply within the confines of private employment. You do not have the right to say whatever you want to at work. Employers can restrict speech at work for almost any reason, such as atmosphere at work, productivity of employees, and the image of the employer. However, those restrictions cannot violate other state and federal laws. For example, speech cannot be restricted if it interferes with the practice of a religion, and may be restricted by civil rights statutes, whistleblower protection statutes, anti-harassment laws, or hostile workplace environment rules. In our next module, we'll look at First Amendment freedoms relating to political speech and protest, including freedom to assemble, protest, and associate. We will also look at allowable restrictions on those freedoms.